evening and welcome to Rights at Night for October. I am Lisa Morgan, a kindergarten teacher and the current president of the Georgia Association of Educators. While we welcome all public school employees, this event is only for GAE members and GAE staff. If you are not a GAE member or part of GAE staff, please sign in by putting your name, personal email address, cell phone number, and school system in the chat to me, Lisa Morgan. We appreciate your interest in GAE. We hope you will join our organization today by visiting joingae.org. Everyone, please note that you must receive prior permission from the GAE Executive Committee or the GAE Executive Director before recording audio or video of this meeting. Social media posts concerning this meeting shall not contain information about the specific content of the meeting, although the sharing of general information about GAE and GAE events is encouraged. Please be courteous to other attendees and request their permission before posting photographs containing their images. If you have questions about social media posting of GAE events, please contact the GAE Executive Committee or the GAE Executive Director. Again, so glad everyone is here today. And I will go ahead and turn our session over to our General Counsel and Director of Legal Services, Mike McGonigal. Mike?
Thank you, Lisa. Well, let me start the screen sharing for my slides. And you can see it, right, Lisa?
Perfect.
Perfect. Rehearsal works, you know. So, well, good evening. So tonight we're going to focus on rights for our ESP members, educational support professionals, also under law called legally classified employees. So what we want to look at, well, now it's not advancing. Well, let's see if I can get it to advance. There, I got to use my roller here.
Okay.
So that's just generally what we're going to be taking a look at. Right to work, what does that mean? What does at-will employment mean? We want to focus on tools you can use, sources of state law, such as the Open Records Act, Open Meetings Act, and what are the federal employment laws that apply to our ESP members. And lastly, very important in this period of time, what are your First Amendment rights and rights of association under the Constitution? So just a quick reminder, when we're speaking with a potential member, we want to let them know that our liability protection provides greater employment protection than other organizations. Our employment and certification defense has no predetermined cap on legal fees and costs, whereas other organizations do cap the amount of funds they expend in defense of member rights. And lastly, we are the only organization that funds affirmative lawsuits against school districts. And I think we'll get into a few of those examples as we get into the presentation. How did we get here? I know history is not dates, but I think especially where we're at, given the political, social climate, it's a good reminder to see where we have come in the last 150 plus years. I didn't put it on the slide, but I was doing a little research. 1955, it also could be a good reminder of the Montgomery bus boycott. I was in Montgomery a couple of weeks ago and went to the Peace and Justice memorials there. And if you haven't been, I highly recommend you go. It's very moving, very powerful. But there's a quote that I want to share with you that touched me, and it comes from a Black woman during the boycott that went over 300 days. And Dr. King was concerned about that she was too tired, and wouldn't she, take a ride in his vehicle. And she responded to him in a profound way. Her name is Mother Pollard. And she said, "My feet is tired, but my soul is rested." And that provides me with inspiration and moral clarity over the physical burdens that, she might endure, or that we might be enduring in this, sort of uh, time in our history, which creates so much frustration and worry. I look to someone like Mother Pollard, who said, "My feet is tired, but my soul is rested." So she had a very clear moral purpose about the bus boycott, which then led to the merger. Eventually, it took a mass movement to get to the Civil Rights Act of '64, Voting Rights Act of '65, and then the pressure for the two organizations in Georgia to merge. And this is a photograph I came across of the gentleman who called the very first meeting of the GT&EA, Georgia Teachers and Educators Association, Mr. Richard R. Wright Sr., another very inspirational person. He was born into slavery. When we went through the war and emancipation, he then was the first president of the Georgia State Industrial College for Colored Youth, which is now Savannah State. And below that information about Mr. Wright, there's a very, very influential retired Emory historian, Vanessa Siddle Walker. And you should screenshot this or Google her name. And she has written extensively about segregated public education in Georgia. In particular, she's written a biography of GAE's first African-American executive director, Dr. Horace Tate, and another book about another GAE member who was an influential principal in the city of Gainesville schools, Dr. Ulysses Bias. And I highly recommend, that you take a look at the work that Professor Siddle Walker has generated, because it's just not the GT&A's history, it's our history. And it's good to know where our roots from and take inspiration from that period in our history. So moving on to some of these, technical words, right to work, what does it mean? So just to clarify, under Georgia law, right to work means that you cannot be compelled to join a union as a condition of employment. And that law was adopted by the Georgia General Assembly, as you see, in 1947, which was also a way to keep racial and economic classes divided, because the facade is right to work adopts the patriotic rhetoric of an individual's freedom to choose, but it hides the reality that without compulsory union dues, then we are divided as a labor movement, and the division is a sign of weakness. And who wins in this? Well, in the public education world, what's happening, what we've seen over the past 20 years, is a big effort to privatize public education. It is being treated through these waivers like a business. And so who wins would be the investors of the charter companies, for example, and who loses in this would be things like the students, of course, because if you can waive class sizes, put more students in the classroom, the quality of education is going to decrease. So we have right to work, but does that mean, can we still form a traditional union? And the answer is emphatically yes. Emphatically yes, we can. And that takes a couple of different explanations. One popular misconception is you cannot bargain. Well, if you've ever bought a house, bought a car, bargained with a significant other, a spouse or a child, we bargain on a daily basis. And so we can bargain with the school district, and we encourage through our local associations to bargain and negotiate terms and conditions of employment. And there's another popular misconception. There's some language in Title 20, which is the education code, that says nothing in this part, it's the grievance statute, nothing in this part shall constitute or endorse collective bargaining. Well, that language has never been tested in court. And I believe that it only applies to when it says this part shall not create collective bargaining. It's really confined and limited to the grievance statute. But the prevailing law is that we need the General Assembly to adopt legislation that would enable us to collectively bargain with a school district. So hopefully we understand what right to work is. That means we can't be compelled by law to join a union. But there's another concept that's also kind of overlaps, and that's at-will employment. And in the red there is a basic summation of at-will employment rule. Means that you can be fired for a good reason, like chronic tardiness, or a bad reason, because I was late picking up my child at daycare or having to drop them off, that sort of thing, which is a bad reason, but you can be terminated if there's a pattern of being late. And last but not least, you can be fired for no reason at all. I don't like, I woke up on the wrong side of the bed and I don't like Mike, and he didn't smile at me, and I'm telling Mike, hand in your keys to the school bus. You're terminated. You don't have to have a reason at all. Good reason, bad reason, or no reason. The origins of this at-will, they go way back centuries and centuries into the feudal system of feudal economic system in Europe. What evolved from that is something language that's still used today in contemporary law. It's called master and servant law. And master and servant, I do believe that is the picture frame or the lens that the current president views him and us. He's the master, we're the servant. I'm totally believe that's how he views his job. I'm the master, you're the servant. I can fire you for a good reason, a bad reason, or no reason, and he's been doing that. Anyway, so there's also that concept at will is transported over here to the New World, and eventually the Georgia Supreme Court ruled in 1853 and incorporated and announced the decision at will relationship between Henderson and Stiles. And there's been that case is still good law. It was a case involving a plantation owner and an overseer, and the overseer sued the plantation owner for wages, and the court said, well, you don't have a contract for a definite term, therefore your employment relationship is at will, and he doesn't have to pay you anything. Well, that's still good law. So, and then in 1910, that idea of at will was then incorporated into the code OCG 34-7-1 in 1910. Again, there are no exceptions to the rule in Georgia. Well, there it is again, the codification. An indefinite hiring may be terminated at will by either party. Again, in 1910, we're still in Jim Crow, and the General Assembly was working with that to divide Georgia workers systematically by race and class, creating those divisions which we still have today. So whom we elect matters. So we've covered sort of the bad stuff, right to work, at-will employment, but what rights as a classified employee, as an educational support professional do I have in a non-union environment? Well, you actually do have quite a few. We're going to look at federal anti-discrimination law. Title VII prohibits discrimination on the basis of race, gender, sex, national origin. You also have rights under the Family and Medical Leave Act, the Americans with Disabilities Act. You also enjoy First Amendment free speech rights and rights of association. We then are going to look at your rights under the FSLA, the Fair Labor Standards Act, federal wage and hour laws. And you also have the state whistleblower law applies to our ESP members. And that basically is a protection if you are blowing the whistle on waste, fraud, and abuse straight to the superintendent and you are demoted or terminated after you have voiced your concerns about waste, fraud, and abuse. That law is there as a protection. So what are some of the sources of state law? Well, they begin at the local level, your school board policies. That may seem self-evident, but this is a good reminder. They are available, should be available online at your work site and at the central office. And so your school board policy should relate to all school employees on matters such as transfers and layoffs, and a grievance or complaint policy should be there in the local board policy manual. Here's I don't know if you can see my cursor, but there, if you were to go to www.legis.state.ga.us, you can then look up the laws that we're referencing tonight online. The next one we'll look at is the Open Records Act. So the Open Records Act presumes, because you're a public employee, that pretty much everything you have on file with the district is presumed to be public unless it's listed in a list of things that are not to be disclosed, exemptions such as home address and your telephone number. Your social security number, can't disclose that, can't disclose insurance and medical information. And I put a question around personnel evaluations because there is a law that says personnel must be evaluated and evaluations are confidential. Now that is in the Education Code, Title 20, but this has been tested in court, and the Open Records courts err on the side of the Open Records Act and have decided that personnel evaluations are subject to public disclosure upon request. So your evaluation file can include all records written electronic, and that can include emails and text messages. Between you and your UniServe director can request access to the file on site at the school or central office, or both. Don't forget 2 locations. And you can take pictures of the documents in there that you wish to record and have for your own records at home. A tip that if you see something in your file that you haven't seen before, you can always attach a statement of context, an explanation, or rebuttal to any document contained in the file. There are no time limits or statutes of limitations. And you should check your file once a year, because there is no law that compels the district to tell you what's actually in your file. Now, it's very rare that you'll find something in there that you didn't already know about, but it's still a good idea to review your file, because, what good are rights if you don't? Hello? So another law that applies to us is the Open Meetings Act, and we strongly encourage our local associations to show up at the school board meetings. And there's always 2, a planning meeting at which there's no public input, but you're still entitled under the Open Meetings Act to sit and listen to what the board is discussing in an open session and take notes and record the meetings. Now there is this unofficial opinion issued by the the State Attorney General's office, stating that a school board can't close any public meeting where you're airing grievances. So for example, if you go to a school board meeting and you wish to address crowded classrooms, too many students, we need to amend our waivers so that we can reduce the class size. And you can be critical of the district, be respectful but critical, and that is another word for that. You're airing a grievance with them, and they can't close you down and say this can only be done in an executive session. The only reason that they can go into executive session over some airing of controversial subjects is for the deliberation process, say in a termination hearing or a non-renewal hearing, things like that. The hearing itself is open to the public, but the deliberations by law may be conducted in private. So you may want to take a snapshot of this. I'm not going to get into a great detail, but I collected as many sources of state law that apply to our ESP members. Code of Ethics. The superintendent can write a letter of reprimand for any employee, from the bus driver, the custodian, to our cooks, classroom teachers, administrators, and you have rights to appeal. You have a right if you're assaulted at school, for example, the first 7 days you are out as a result of being physically assaulted, they cannot deduct your sick leave from your allotment. And then you can go down the list. I'm not going to, just read them to you, but strongly encourage you to take a snapshot and keep that in your filing cabinet in your own time. You may encounter some disruption at the school bus, where there's a law that prohibits disruption at the school bus stop and on the bus. And there's your law, 20-2-1181, that you would cite to administration. Another source of rights is your workers' compensation statute. If you are injured on the job, that under the NEA GA Legal Services Program, that is not something that is covered through us, but we can put you in touch with a workers' comp attorney to represent you in your workers' comp claim with the district. Now, what workers' comp attorneys do not do, and they will tell you this, they do not address Family and Medical Leave Act issues, which are common in workers' comp issues, or the ADA, the Americans with Disabilities Act issues that becomes very important when you're returning to work from a workers' comp injury. You may need accommodations when you're returning to work. That's when you would come to us, or your UNISERV director can help that ensure that accommodations are made, or the FMLA, that you are being granted proper leave under the FMLA, because the workers' comp lawyers aren't going to handle that. So did I jump over? Okay, I did. So briefly, the FMLA covers employees who have worked full-time for at least 1 year. And while you're out on leave, and this is the really good thing, is the district must hold that your position or a substantially similar position and maintain your health insurance. So there's a job protection there. Now, the FMLA by law is unpaid. However, you can use your accumulated unused sick leave if local policy allows for it. And most school districts do, in my experience. So when you're taking FMLA, there's always some paperwork, the medical certification that your doctor fills out, sends it back to the school district. Intermittent leave, FMLA doesn't have to be taken in big blocks, like 1 month or 2 months at a time. It can be intermittent, meaning to go to physical therapy appointments or cancer treatment appointments, doctor's appointments, as long as you are being treated for a serious health condition. That's one of the main conditions of being granted FMLA, is that you have a serious health condition or an immediate family member has a serious health condition. It also allows leave to care for a newborn baby as well, or the adoption of a child. Okay, another federal law, a very good law, is the Americans with Disabilities Act. It provides an equal opportunity and levels the playing field. It's actually an affirmative action law. It requires the school district to take affirmative steps to provide an equal employment opportunity. One of the conditions is the district has to engage in good faith discussions. When you're making requests for reasonable accommodations, they must treat that, seriously, with sincerity and in good faith, that they're going to work with you and just simply not ignore you, or just sort of blow it off. I don't find a lot of districts blowing it off. What I usually see is the employee submits a list, a reasonable accommodation with this idea can be that it's my wish list and I'm guaranteed my personal accommodation, when the law says it must be reasonable. And we can spend a lot of time going into what's reasonable, what's not, and what we can live with, what we can't. So, but here's some real basic accommodations that are very common. Sitting during instructional time for a classroom educator or a paraprofessional. Or if you have lifting restrictions, is another one. You can have snacks in the classroom or on the school bus if you're a diabetic, or an air purifier if you're asthmatic. The one thing that we do push back on is the district pretty much has to grant reasonable accommodations, but they cannot argue that it's too costly to. It's a cost or it's an inconvenience. They can't. Courts don't buy that. We had it was a classroom teacher member, but she needed a handicap disability parking spot close to the school entrance. Well, the one that they gave her was quite a distance and up a hill. And what the law says, that you must attempt the accommodations that's granted, but if it's not effective, then the district has to give you another accommodation. So we are able to convince them that, look, yes, she has a disabled parking spot, but it's too far away from the door, and it imposes a hardship on her. She gets tired easily. She has to unload her mobility device and all the rest of it. And it was just a bit much. And so we were able to secure the disabled parking spot closer to the school entrance. So here's a really important one, is the Fair Labor Standards Act, FLSA. If you're a classified employee, you need to get this handout here. It's a little bit of a guidebook. 29 CFR. CFR is Code of Federal Regulations. 29 CFR Part 785. It's entitled Hours Worked. I had a bus driver years ago hand this to me and she told me, this is her Bible, and I want this to be your Bible. And it's very, very enlightening, very helpful, explaining hours worked and your rights under the Fair Labor Standards Act. So one of the first things that I've learned is that you cannot volunteer to do the same work for which you're actually being paid to do. So suppose at the end of your shift, you're a paraprofessional, and you stay at school to finish and assign tasks. Maybe you're, helping the teacher with grades or preparing student records, things of that nature. And if the principal knows that you're staying late after regular business hours, that's compensable time. That counts. The district, the principal has to make it extremely clear that you are relieved from duty and you should go home. They have to make that abundantly clear to you. Otherwise, they're accepting your labor for free, but the law says they cannot do that. Another example would be employees must be compensated for all waiting time. I've seen that, of course, applies with our bus driver members. Unless you're completely relieved from all duties and allowed to leave the premises as you see fit. And I like this little quote from the United States Supreme Court from a 1944 decision, and what they wrote on this particular point is that the employer can choose to hire a person to do nothing or to do nothing but wait for something to happen. Waiting time, that's compensable. So they can hire you to wait or do nothing at all but wait, and they must pay you for that. So now we're going to shift to something that's a little bit fun. Is it a gripe or a grievance? All grievances are gripes, but not all gripes are grievances. So there's a little checklist here that some of you may be familiar with. I know our UniServe staff is. So we look at it. Is it trivial in nature? Like, my supervisor's treating me differently than others, and it seems unfair. Well, that just may be, how things are. That you are being treated differently, but it may not rise to the level of a concrete violation of a law, rule, or policy. It may not be discrimination, illegal discrimination. Or is what's driving this is a personality conflict? So if you're being treated differently, maybe it's really being driven by a personality conflict. And we can work with the boss to, get these issues out on the table so that we can have a harmonious working relationship. And so what's a viable remedy? What's your desired outcome? And is it realistic? So if you do get to the grievance stage, I wouldn't be even asking for an apology for whatever issue it is that we're grieving, because that's not in the realm of reality. We want a viable remedy. Maybe it's a rebooting and a redressing of the relationship. So moving forward, this is how the parties are going to act. And is the member serious about standing up for his or her rights? Again, as I said earlier, like with our rights to our personnel file and Open Meeting Act rights, we do have those rights. But if we don't use them, then they just simply go to waste. I apologize for all seems a little cramped there, but so following situations, the head custodian, number one, head custodian calls and says that a subordinate rank and file custodian calls and says the head custodian does not do her job and I want her fired. Is that a gripe or a grievance? Well, 9 times out of 10, that's going to be a gripe, and not a grievance. Plus, we don't have the capability or legal authority to get somebody fired. But we do take gripes seriously, and we can bring those to the attention of administration so that the parties can have a good working relationship, because nobody, because nobody wants to be walking around in a toxic work environment. Two, my manager says that my day begins only after I start the engine when I begin my bus route. No, because pre-route instructions and post-route inspections are compensable. And I don't know, I'm sure we have some bus driver members, but I have heard this before. Bus drivers being told, no, we only pay you when you start the engine. No. And I've also heard number three, I'm allowed to park my bus at home. But during a storm, a tree fell on the bus, and my transportation director told me to file a claim with my homeowner's insurance policy. Now, this may not really be a grievance, but it is serious. And once we, inform the director or the superintendent that you all have property insurance covering the buses, you cannot compel the bus driver as a term and condition of employment to put it on their homeowner's insurance policy. That's again, that's just a way to rob you and enrich the district. Four, transportation director told me that I don't get paid waiting time during field trips. Well, we already covered that. Supreme Court in 1944 said an employer can choose to hire a person to do nothing or to do nothing but wait for something to happen. Five, my principal told me, I'm a paraprofessional, to clock out at lunch. But then he tells me I must eat my lunch in the cafeteria with the students. And then after my lunch, I clock back in. Well, this actually happened. And that time spent eating lunch in the cafeteria with the students, the paraprofessional was actually working because she was supervising. And the principal thought he could spare some overtime, some, treating this paraprofessional unfair. He thought he could get away with that until he called our UNISERV director. UNISERV director calls me, and we put a stop to that practice and got the paraprofessional her back pay. And I do know that the district took it so seriously, he was falsifying federal wage and hour records. That's technically, you could there is jail connected to something like that. But he did get a PSC ethics complaint filed against him. He was not a GA member, and I don't know how it turned out, but there were some serious ramifications for falsifying timesheets under federal law. So now we've covered our federal laws. Now we're going to get into educators speak in the wake of political violence these days. We want you to be informed and be educated and to know your rights, to be safe on the bigger picture. This is all about our democracy and how we protect it. So we're all familiar with the right of freedom of speech. We do know that it is not absolute. It doesn't give us the right to say what we want, whatever we want, to whomever we want. There are some rules attached. So what we do know from centuries of Supreme Court decisions is that the First Amendment protects you as a government employee strongly only to the extent that you're speaking as a private citizen on matters of public concern. So that means after work hours, you could be doing social media, even better on your private side of your social media on a matter of public concern. And we'll definitely get into examples of that in a moment. But if you do speak to a school board, then we would advise that when you get up to speak to your school board, who's your employer, also say, I'm also here as a citizen. I pay taxes, I may be a voter if I reside in the school district. So use your other statuses to provide other layers of anti-retaliation protection and utilize your local association. We need to get more in a habit of acting together and in groups. What we're facing today, trying to change what's happening on your own is a losing proposition. We do have to act collectively and also reach out. The other thing we should do more of, is have partnerships with local community groups in faith institutions. We all need to come together because we are all in this together. So a couple other rules that your public employee speech is not protected if what you have to say is spoken within your job duties. If it's within your job duties, there's a Supreme Court case that came out of, I think, a little around 10 years ago called Garcetti. And it was a district attorney in Los Angeles who was blowing the whistle on the police force out there they were fixing tickets left and right. So they were committing fraud, illegal activities. And he was disciplined for speaking up about that fraudulent activity within the LA Police Department. Well, the case went all the way to the US Supreme Court. And the John Roberts Court said, well, because your job as a district attorney is to ensure that laws are enforced, it was your duty of your job to inform others about this fraudulent ticket fixing that was going on in the LA Police Department. So they decided that under the federal US Constitution, that was not protected speech. And it's still a headache for us. And we still, lawyers, civil rights lawyers, it's pretty shocking that the US Supreme Court would not find that protected. But what they did say, you should look to your state constitution and your state whistleblower laws. That's what they said. But that's an example of the US Supreme Court and federal government withdrawing and slowly taking away federal protections and going to the states. Okay, and now we're seeing that on steroids. Your speech, even if it deals, or your speech wouldn't be protected if it dealt with private or personnel matters. I think that makes a lot of sense. And also your speech, if it disrupts the workplace, even if it is a public concern, courts would not find that protected speech. And there's a case we'll have an example of what that means in a moment. And of course, if your speech is unlawful, if you're inciting violence, or if you say something, a false fact, like the English teacher in North Georgia, there are people on social media saying that our member was a sexual predator and she was grooming students because she had young adult novels in her classroom with a sign that said parental permission required. Well, they said some very untrue, false things, labeling her a child predator and groomer and the rest of it. So they might have a right to free speech, but they do not have a right to say false things and defame another. So, some guidelines here that we are using about posting on social media without fear or retribution. So we're just urging caution. Do not, and this of course comes out of the aftermath of Charlie Kirk. We all know that. It's not a good idea to condone or even comment on, celebrate the death of anybody's violence. Certainly on the public side of social media, you're broadcasting it, you're setting yourself for extremists out there who are looking for that sort of content, and the educator will be doxxed by the extreme right-wingers out there. Just be respectful. Don't use obscenities or slurs or things like that, or express your own personal, private, political opinion, because again, there are ways that our forces against us are going to twist that as you representing the school district. So we want to avoid that situation. So this is just a test, a think test. THINK, the Minnesota Association, put this out there for their members. I thought it was thought it was good, so share it here. Is it true? Is it helpful, inspiring, necessary, or kind? Uh, we always, you know, want to follow something like this, helpful guidelines before posting, but we also want to be clear that there's a lot of manufactured outrage out there that is causing disruption, that the educator, the public employee may not be the cause. They might be well within their rights to express opinions, but then that's been taken advantage of by extremists out there. So helpful guidelines, and this is a PSC guidelines. And I thought this is pretty helpful. The who, what, where, when, and why. Who am I? What's my role as an educator? And these are just get you to just slow down and reflect on what it is that you're saying, because in the online world, it's like react. I would say, look, just slow down before you react, because that's what they're hoping you do, is just react, and say something that can be twisted into something that you didn't intend. Nothing is private, nothing's permanently deleted, and that includes Snapchat, which I understand it's marketed as something that you send on Snapchat and it dissolves rather quickly, but it is in their servers for at least 30 days. So it even Snapchat is not permanently deleted. So the next couple of slides, two slides, these are guidelines that federal courts across the country look at when analyzing private speech on your own time, when looking at the content of the speech, okay? And there's no one universally applied test, but these are some of the things that a court is going to be looking at. They're going to look at the importance of the issue. They're going to be looking at, are your views just critical, or are you celebrating death and violence? That's going to be a factor, not the only factor, but again, that's what courts are looking at. They're going to look at the time, place, and manner of speech. All I can say is you need to control your privacy settings, and your social media activity should be on the private side, no matter what it is. You got to protect yourself. I wouldn't be commenting on anything political these days, given the climate. Again, we're trying to keep you safe on the public side. That's, it's depending on the content and what you're saying. What I know from the Kirk situation, keeping it private is extremely important. So the courts are also going to look at the nature of your job. Are you a classroom teacher, paraprofessional, administrator? Courts are saying, if you are directly responsible for a safe and supportive educational environment for all students, then that speech is going to be called into question as to whether or not you have an ability to treat all students or families fairly. Now that may not seem fair, but again, that's what the court is going to be looking at, the nature of your job. They're going to look at whether your speech, what type of effect it's going to have on workplace discipline and harmony. So are we really dealing with hurt feelings, or does it actually, in fact, undermine supervisory authority? Oh, I used to trust Mike, but he said these things, and now I'm not so sure I can trust him now. And if you have testimony along those lines, that testimony can become evidence against Mike. So, and it doesn't take a whole lot of that evidence. And then courts are looking at, rightly or wrongly, the level of public outcry. And it's called a heckler's veto, is when you have somebody that you are going to have a speaker at a rally, but the district or administration of the school determines in advance that the speech would be too disruptive. And so the people who are heckling the speaker, they get the administration to remove the speaker from their speech. That's also called a prior restraint on speech. And even though the speech itself is protected, political climate comes into play in some of these cases. And they're through the heckling and the doxing and the cancelers out there, they're rewarded by the level, the huge public outcry that is generated in some of these cases. And then finally, what is the nature of the employee's evidence of disruption to the workplace? They just can't make it up. There has to be actual evidence of a disruption. So this is the case that we use to teach about a teacher's off-duty Facebook posting on the public side of a local radio station in Tifton. It went viral, and it caused an outrage in the city of Tifton, and she was posting about BLM marchers, Black Lives Matter marchers during a holiday parade. And if you look up the case, Atwater v. Tift, what is that site? 343 Georgia App 301 2017. She said some very, very racist and disgusting things, such as pull up your dang pants and quit impregnating everybody. I'm tired of paying for these sorry ass thugs, is what she said. But the African American community and African American students at Tift Middle were really shocked and taken aback, and it caused quite a disruption at the school. Well, the district had a hearing, and they imposed a 5-day suspension without pay and sensitivity training. But she wasn't a GA member, but she did file a First Amendment lawsuit, went up to the Georgia Court of Appeals, and they said, well, yeah, you were on your private time, and you were speaking on a matter of public concern. Criticizing Black Lives Matter may be your right. Offensive speech, you have a right to offensive speech. But where she lost was the disruption to the school. That if you were one of her students and you're, student of color, and you were reading these things about what your teacher said, that'd be pretty hurtful. So she lost her First Amendment claim based on the disruption element. So what can I do? In your personal capacity, on your own time, you can write letters to the editor. Just be respectful, make sure it's on a matter of public concern. Again, I keep coming back to class size. That doesn't help kids learn. What about things like duty-free lunch? There's some very good issues in the educational area that you can write letters to the editor on to raise awareness of the quality of education in the school. You can engage in political activities, marches and rallies, obviously, and protests. You can attend fundraisers. Some of our locals have political action committees. You can sign petitions that call for something to be done with the superintendent and or the school board. Just be sure, I'd be more than happy to review the language of the petition, but just be sure that there's not something in there that you're advocating for some sort of crazy violent overthrow. Not that you would sign that petition, but there are certain language, certain triggers in some petitions I've seen that are a little bit concerning, but you do have that right. And obviously, you can provide public testimony at a school board meeting that's critical. And I like the phrase here, inform but do not inflame. Just lay out the facts, stick to the facts, and thank them for the opportunity to speak to the issue. A couple more scenarios. You participate in a weekend rally protesting police brutality. That is protected speech. And of course, we did have a case like this when our GA member Jeff Corkill was protesting during the first Trump administration, the family deportation policy. And he was protesting downtown Atlanta, and he was arrested, and it was on the local news. Well, that was during the summer, private time, nowhere near school. But when he gets to school, the principal pulled him inside and said, "Hey, I see that you got arrested. That does not reflect well on the school, and I'm going to write you up on your TEKS for unprofessionalism." That actually happened. Well, long story short, we gave Gwinnett County Schools the opportunity to remove that from his file, and they did not. So we filed the First Amendment lawsuit, and within about 30 days, the whole thing had been settled. So they learned their lesson there, and you should be proud to be a part of an organization that'll file federal lawsuits protecting your rights. Other organizations don't do that. So you post on your Facebook wall a local newspaper article favorable to a political candidate. Yep, that's protected, and that can be public facing. You support whomever for governor, state senator, U.S. senator. That's not a problem at all. It's like having a yard sign in your front yard if you own a home. Or you write a letter to a publication, local newspaper, that's critical of the school board for one of its actions or ideas. Yes, protected First Amendment, but remember, inform, don't inflame, be respectful, stick to the policy, not the personalities and not the people. You want to focus on the policies and not the persons. You're a transgender woman and you use Ms. title and pronouns, she and her, and you prefer that others, including your students, do as well. Yes, that is protected, and we have a recent Florida federal court decision from last year, and the question before the court was whether the First Amendment permits the state to dictate how public school teachers refer to themselves when commuting to students. And in the first paragraph of that decision, the judge wrote, "The answer is a thunderous no. The school district has no right to dictate to you how you refer to yourself as a transgender woman." And the last one, so you're instructed not to discuss with students your personal opinion on political matters, but in a classroom discussion on racial matters in America, you tell your students that you recently participated in a Black Lives Matter demonstration over the weekend or something. And that's kind of a close call. I'd say that's in a gray area. It depends on how, other factors, do other educators, do they, discuss they were in a pro-MAGA rally and they weren't harassed or written up. Sorry about that. So it's a bit of a gray area, but I will say if you've been told not to discuss personal political opinions in class, we need to be real careful to follow that or be insubordinate. So I know I'm getting low on time, but because we're dealing with ESPs, I just want to speak on the Liz Cook case. So Liz Cook was the president of the USEA at the time. The Gwinnett County had two local associations, one for the teachers, the actives, and the bus drivers created their own bus driver local, the United School Employees Association. So Liz Cook was a very active member, and she was advocating about how to improve the safety of children in school, and believes that well-trained and motivated employees are one of the keys to school safety. Now, these words on this screen, that's taken exactly from the court decision. And the mere fact her speech was made to coworkers or to supervisors rather than to the general public does not remove the speech from the category of public concern, which is real interesting because this is one of the few times when your speech at work is found to be protected. But look at what it was matters of public concern. So good for Liz. Dang it. Here's another important takeaway from the class. When she was advocating, Liz did not disrupt the workplace, excuse me, or neglect any specific job duty. She's very careful. You know, she went to the we didn't have rights at night, but I know I went to the local, I provided training, we had other attorneys, we provide training and, you know, consultations. So she had also lobbied at the state capitol on behalf of bus drivers and took photographs of USEA members to help promote the lobbying effort. Now, again, this quote on the screen is straight from the court decision. Now, here's the more important takeaways here. Liz did not engage in any USEA local association related speech while transporting the children or performing her other job duties. She would do that on her waiting time during the route, in between her routes, and during downtime, right? So she was real smart about when she was engaging in organizing activities. Like, another important thing about, we want our plaintiffs to be good plaintiffs, what we call, clean plaintiffs, fit the good profile. She had absolutely no negative evaluation. So she, presented well to the court. And Gwinnett County was making an argument, well, her speech was interfering with the efficiency of the workplace. Well, I want to say, duh, the court even said that your argument's undercut by the fact that Gwinnett County Transportation freely permitted her activity. And they even participated in various solicitation. I know they had a food drive and clothing drive during work hours, and they also permitted the United Way free reign to do what they wanted to do, pretty much what Liz was doing and the USEA was doing on school time, but the United Way was not punished in any way. So there we have it. So we're wrapping up. Thank you for your time. If your rights or think your rights are being violated, UNICEF directors, your first point of contact. They work closely with the legal department. And of course, we want to organize, and always keep in mind we're in this together and we are stronger together. So let me stop the chat, stop the share, and we thank you. You're on mute, Lisa.
Thank you, Mike. And I'm going to say there are 2 questions in the chat, and I will direct those members that these questions both deal with specific incidents. So they really should contact their UNICEF director for those issues. And I will thank you all for being with us this evening, and everyone have a great rest of your night.